All right, next up, we had an order in a pending case that came out after our last episode. This is the Moore v. Harper Independent State Legislative Doctrine case. So I'll read you. The parties and the Solicitor General are directed to file supplemental letter briefs addressing the following question. What is the effect on this court's jurisdiction under, it's going to list some things we'll get into in a second, of North Carolina Supreme Court's February 3rd order granting rehearing and any subsequent state proceedings? What does that mean, David? Remember, we talked about the two cases this term that could end up getting digged, kicked, whatever.
Yeah.
One was that when states get to intervene in the immigration case, and it happened again, and that got digged. And the other one was this one because the North Carolina Supreme Court was like, JK, we had an election. We now have a Republican Supreme Court, and we'd like a do-over. So we're going to rehear the case, decide it differently, and that will potentially moot out the Supreme Court case. And so what's interesting here is the Supreme Court is not going to decide this just on their own. They're neither going to dig it nor moot it out. They're going to actually ask the parties, what do you think? Which makes this at least a closer call than I thought. David, there's two things that are interesting about this to me. One, in particular, they're saying, what is the effect on this court's jurisdiction under Cox Broadcasting Corporation versus Cone? That's a 1975 decision on when the Supreme Court can take something from a state court, like can get an appeal from a state court that's not final. That's going to be really interesting as, again, we litigate more and more of this stuff. When we talk about interlocutory appeals coming all the time from the federal circuit courts, but coming from a state court, it's supposed to be final, except if they really want to. And so in that sense, now that the North Carolina Supreme Court's taken it back, does it retroactively make this interlocutory? And we didn't really get into this when we talked about it, but even when the North Carolina Supreme Court decided it before, there was both sort of the merits decision and the remedial part of how the map was going to work moving forward. And so was it ever final? Ugh. Okay, but the second part that's really interesting comes from our friend Will Bode, friend of the pod. And he's got a different question to ask. I don't have a strong view about the finality question the court asked about, but I have been puzzled by a prior, related jurisdictional question. Did the North Carolina state courts have jurisdiction to grant rehearing on the merits? I.e., how did they get it back? Once the Supreme Court takes something, they took it. It belongs to, they have the pen. For anyone who's ever written in a group, not everyone's editing at the same time. That would be a mess. So once someone takes it, they have the pen, and until they relinquish the pen, you can't edit it. That's sort of the theory of how the Supreme Court works when they grant cert on something. Reading again from Bode. It is a general maxim of federal jurisdiction that a lower court loses jurisdiction of a case while an appeal is pending. So far as I can tell, this rule isn't entirely mandated by a federal statute. It's just understood to be a consequence of the way appeals work. Similarly, at common law, a writ of certiorari takes the record out of the custody of the inferior tribunal, leaving nothing there to be prosecuted or enforced by execution, and operates as a stay of execution. If that principle applied in Moore v. Harper, then the issue would not be whether the Supreme Court has lost jurisdiction over the case, but rather that the state court might lack jurisdiction to take such actions. Is there some reason that principle would not apply? One is that this, the Supreme Court has the pen, doesn't apply to state courts for some reason, he says. Okay? But another is that the Supreme Court, when they took certiorari before, used to, take the case, whereas now they're only taking these questions presented. And by only taking particular questions, are they then not taking the entire case? And as he points out, that's not how certiorari worked at common law. And so maybe with that change, the certiorari jurisdiction principle has changed too. I've never heard anybody say this, but it's possible. And he says a third possibility, and I suppose it is the most likely, it is that it has something to do with what is called the two-track approach in this case. And this is what I was sort of referring to. This case went on two separate tracks after the original North Carolina Supreme Court decision finding a partisan gerrymander, the elections clause track and the remedy track. And so if they only took one track, then the other track remained down in North Carolina, yada, yada, yada. David, any of this interesting to you?
It is so interesting to me, and it totally labels me as the most hopeless nerd in the world. So, like, there are a few things that will label you as a ridiculous nerd. One is, can you have a heated conversation over whether it was true to Superman that he killed somebody in Man of Steel? Another one is an extremely angry confrontation over the portrayal of Galadriel in Rings of Power, over whether she was too much of a warrior princess. And the third is, does the North Carolina Supreme Court have any remaining jurisdiction over this case?
And specifically, if we take this two tracks view of it, which I think I do, that there was the remedy track and the elections clause track, the Supreme Court certainly granted review on the elections clause track, and that is what the North Carolina Supreme Court has said they're going to rehear. So what now?
Yeah. So for you law students and legal practitioners and people who have a healthy legal practitioner practice in your mind, this is a really interesting sort of 101 situation, because when a case is appealed, the case technically doesn't even exist at the lower court anymore. It's gone. It's in another court. And so all of your proceedings regarding that case are in the one court as a general rule. And so therefore, is this even the North Carolina Supreme Court's case anymore? Or is it only the United States Supreme Court's case? It's, as soon as I saw that post, I was like, one, I thought it was fascinating. And two, it told me how rusty I am as a litigator, because that should have been something that would have been like the first thing to come to my mind back in my heyday, Sarah. But I regret to tell you, I think I'm past my prime on litigation issue spotting, because it was like so clear and obvious, and yet nobody was talking about it.
There is something that appeals to me, which is his number 2 point on maybe state courts are different. They are separate sovereigns, the federal system and the state system. And so regardless of how it works in the federal system, I am for some reason much more sympathetic to the idea that, like, no, the state courts can just do whatever they want. And then when I say that out loud, I'm like, no, I don't like the state's court doing whatever they want. What? No.
Right. Like, imagine you have your certiorari's granted, opposing briefs are filed, and then you go, you know what, man, the opposing side had some really good arguments. Let me go make a motion back at the lower court to see if they can reissue their opinion in a way that's going to respond to some of these glaring issues. No, that's just not the way this goes. It's very interesting, Sarah. It is very interesting. And I have no idea if the court is going to deal with the Wilbode point at all, but it is super interesting.